Hello out there, this is the irate veteran coming at you with a new video. Any veterans out there needing any veteran to veteran advice, go to vamadness.com and I'll be happy to advise. Also, my book is out. Make sure you get a copy. Every veteran, matter of fact, every American needs to read it. Let me shout out a thank you to my sponsors. I am not recommending any specific lawyer or law firm to veterans. Veterans need to conduct their own due diligence before selecting a lawyer or law firm as their representative. That being said, thank you, Mr. Kindle and Hill and Ponton, and Mr. Rada and West and Dunn. There's links to their websites at my website. Let's get into our video. All right, so today we're going to cover rating reductions. And let me tell you something. Facts can fight your reduction. That's what this is kind of all about. So right now I have a friend of mine who's going to help me explain this.
I'm Greg. I'm the owner and founder of After Service, a law firm by a veteran for veterans. I'm a Air Force veteran. I was a C-17 loadmaster in the Air Force from 2002 to 2008. Went to law school, and now I do VA disability benefits.
All right. Since we know that you know what you're talking about, actually, I give all lawyers credit for knowing what they're talking about. Especially, like I said, before in other videos, I'm married to one, so I would never say they don't know what they're doing. Otherwise, I'll get chewed out. All right. So a lot of times, reductions start with the heart attack letter from the VA, right? Saying you're going to get lowered and you've got 60 days or you're done for, right? And this isn't something to mess with. It's going to happen if you don't do something. One of the things you can do, of course, to delay it, or I don't even want to say delay it, if you're not ready, right? If you need to get ready, you have, maybe evidence to gather or get your statement together or just get over your frustration. You can ask for a hearing. So tell me, what are the benefits of a hearing?
So like you said, you never want to ignore the letter. If you ignore the letter, the 60 days are going to pass and VA is going to finalize that proposal and they're going to reduce you. In my practice, I always request a hearing for these reasons. One, VA can't reduce the rating until they hold the hearing, and it generally takes them anywhere from 6 to 12 months. I've had a case take 18 months for VA to schedule that hearing. And so during that time, you're buying yourself valuable time. VA can't reduce the hearing, so you'll continue receiving your current payment rate until that hearing is scheduled and held. It's an informal hearing. You're not going to have to travel. They do these over the phone or Microsoft Teams now, so you can do it from home. And it gives you the opportunity to speak directly with the VA about why they're wrong and why they shouldn't be reducing your rating. And so aside from making your case, I think it gives a human element to the case. I think it's harder for the VA to reduce something after they've spoken with the veteran and heard in the veteran's own words why it shouldn't be reduced.
Yeah, I think that you're right. It's really important to get that personal connection so the VA, at least their representative, can understand, your points. Now, you're saying here that a C&P exam, they might allow that per the hearing, a new one?
Yeah, they generally will go by what a C&P exam says. And if a veteran's telling the decision review officer, hey, this rating reduction is not warranted, my symptoms are worse, usually the decision review officer will come back and say, okay, would you agree to go to a new examination? Which could be good or bad. Ideally you go to a new exam and it supports your current rating, but it could happen that you go to another exam and it supports the reduction. And, now you have two C&P exams against you. Right.
But at the same time, I think if it's offered and there was a problem, a lot of veterans cite problems on their exams. The examiner, went really fast. It was a short exam or didn't ask a lot of the questions that are on the DBQ, just skipped over them. In those cases, it's probably best if they offer the exam to go ahead and take it. So, and we're going to talk about that also here in a minute about how exams relate to lowerings in another way. One of the things I wanted to mention, and here's the regulation for revision of decisions, is if they're not actually going to reduce your payment, they don't have to notify you that they're going to reduce that rating. Is that correct?
That's correct. They'll just go ahead and issue a rating decision that lowers it.
Yeah,
Your
so
combined rating stays at the same.
and really there's nothing you can do about that because you don't even have the opportunity, right? It's all of a sudden bang, you're lowered.
Right.
So
You do want to still appeal that.
naturally.
Yeah. You don't have a way to head it off, but you can definitely appeal it and still fight
Right.
it.
And which, again, after we're done with this, people to know that you absolutely should do that. And then I wanted to talk about this is a really, really important part for reductions, which is why it makes it very difficult for the VA to do reduction. Because according to this highlighted couple of sentences I have here, the rating schedule not only has to show improvement, but there has to be improvement in the conditions of, functional improvements for conditions of life and work. Those are two things that, okay, the rating schedule part, maybe that's not hard to show a reduction, but to show that your actual condition has improved, now that's more difficult. What do you think about this part of the regulation?
This is the crux of any rating reduction case. This is the most important thing. VA has to make this finding in any rating reduction case, regardless of the length of time that you've had a rating. Later on, I cite you a case that also indicates the rating schedule actually doesn't matter, because the question in a rating reduction case is not whether a veteran continues to meet the criteria for their current rating, but whether this finding can be made. So this, to me, is the most important thing.
Yeah, I completely agree. I have a few disabilities, and of those, there may be times where if someone was to test me, it would be better at those times. But
Sure.
Functionally speaking, I still have the same problems with standing for extended periods or walking upstairs. So functionally, I haven't improved any. And they would have to determine that, in fact, my function hasn't improved to lower me, right?
Correct. Yep. And I've never seen a rating reduction case where the regional office makes this finding.
They gloss over it.
Yeah, we're going to talk about it later, but they have to make that finding. It can't be that, your forward flexion is now 60 degrees or less, so we're reducing your back from 40 to 20. That's improper. They have to make this finding.
Especially unless the examiner says something, I tested him going up and down the stairs and he's now good to go. He can run.
Right.
Anyway, so let's move on past this and just talk about some basic reduction fact. The first one's pretty easy. If you haven't held your rating for 5 years or more, they can reduce you with a single exam. That's just a fact that veterans have to deal with. But when it comes to 5 years and over, there's some rules. We're talking about sustained improvement. What exactly would that be?
Sure. So that goes to the single exam requirement. It has to be sustained improvement. And so a single exam showing improvement is not enough to support a finding of sustained improvement. It's got to be improvement over a period of time, not just a single snapshot.
And typically what I see is a veteran will contact me, say, hey, I got a C&P exam coming up. Then later he'll contact me saying, they did that exam, but they scheduled me for another one. and often I'll say, okay, they may be looking to reduce you. So make sure you if you haven't got a good statement in, get a good statement in about your functional issues. But there's another part about these exams. This part here where it says less full and complete. Often when I look at exams and then look at a later exam, I'll see that sometimes they don't match, right? Like for instance, there may be someone who's doing a knee exam and they have to take active measurements, passive measurements, repeated use over time. There's different measurements that they're supposed to take, right? So the idea is when I see some of the later exams, they haven't done all those things that they initially did. So is that where this less full and complete comes in? The exams that they do that they initially awarded you, it has to be the exact same things that were covered on the lowering exam to lower someone.
Exactly. Yeah, I see this a lot in PTSD exams or other psychiatric conditions. The initial exam will be this amazing dissertation going into every aspect of the veteran's life. And then the reduction exam, is like a sentence under each section. And so DROs, if you do a hearing, you can argue that. You can say, look at this first exam, look at this second exam. It's clearly less full and complete than the first one, which again will usually result in VA offering another exam.
Yeah, so that makes it pretty clear, after 5 years, they have to, or 5 years or more, they have to show sustained improvement, but then exams have to be basically identical.
Yep.
So that's another thing that needs to be looked at if they're going to propose a reduction. And then, of course, most people know about the 20-year rule, right? If you've held a rating for 20 years, the VA just can't reduce it. That's just the way it is. Now,
Correct.
They can sever it at some point if they think there was fraud, right? But as far as a reduction goes, that's not going to happen.
Yeah. And a point here, when vets get their P&T rating, they often think that that means it's permanent. Even P&T is not permanent until you've had it for 20 years.
Exactly. But,
right.
Here's some of the things that I think a lot of veterans don't know about. For instance, if you have a 100% rating, how difficult it is for the VA to lower that. Could you talk about that?
Yeah, it's a higher standard. There has to be material improvement, which is just a higher legal standard. And in addition, if VA is lowering a 100% rating, they do have to consider whether TDIU is warranted. And we're going to go into that. If you have a 100% rating, VA is proposing to reduce it, they have to consider whether they could give you a TDIU instead of the 100% rating.
When it comes to the TDIU part, does that still require material improvement, or is there other rules for TDIU?
TDIU has its own separate rules. So one of the important rules is if you're on TDIU and you start working, VA is actually not allowed to terminate TDIU until you've maintained substantially gainful employment for 12 consecutive months. A lot of vets don't know that. So if you're on TDIU, you can attempt to return to work. And if you're unable to do so, you start a job, you only work for 6 months, you stop working, your TDIU will continue.
Let's say, though, that you met the minimum rating at 70% and they're doing a reduction of one of your disabilities, and now it's going to drop you to, let's say, 40%. So they would still have to show that you're employable also, right?
Correct. They can't just reduce the unemployability, although the regional office often does what it wants. And so don't be surprised if you get a letter saying, sorry, you no longer meet the scheduler requirements for scheduler TDIU, and they try and terminate it.
Right. And again, here, if they don't have the finding that, yes, it looks like you're employable now, then you still have a way to fight that TDIU withdrawal.
Absolutely.
So let's move on to preservations of disability ratings. One of the things I wanted to mention is when the schedule changes. If, for example, the schedule changes and you ask for an increase and you were previously rated at an old schedule, can the new schedule then reduce you? Is there any limitations how that would happen if you no longer meet the schedule requirements under the new schedule?
No, you're entitled to your rating under the old schedule. Again, VA can still reduce, but it's under the standard of actual improvement in the ordinary conditions of life and work.
So that still applies. And there has been some proposals of changes where, knees were a good one. In the old days, instability, you only had to say that you were unstable. And often they would award instability based on your statement as well as witness statements about having instability. But under the new schedule, there's specific requirements for instability. If you went and had a reexamination, they might say, well, okay, you don't have torn ligaments, so you no longer qualify for that instability rating. But again, if you still didn't have improvement, in other words, you still saying your knee's unstable, then they still couldn't reduce you.
Correct.
Wow.
But again, the regional office does what it wants, regardless of what the law says.
Right. So, and that's what we're pointing out here, what the rules are and how to fight it, because as I know, the regional office often just ignores their own rules and regulations. But anyway, this is an important part. If you ever get lowered because the schedule had changed and you asked for an increase. And by the way, I've seen veterans ask for increases when they were already at their maximum rating, which of course drives me crazy when they do that, because then there's only one thing to do, is go down. So veterans, make sure you check the schedule before you ever ask for an increase.
Yes.
One of the things I think some people, actually, I get contacted quite often by people saying, I'm so worried if I ask for a new rating, a new disability, claim a new disability, that they're going to look at all my ratings and redo everything. And I always tell everyone that VA needs a reason to re-examine you. And they do have some reasons that are in the regulation. And one is re-exams every 2 to 5 years. So they they can re-examine you every 2 to 5 years. And down here a little further, it says if you have static conditions, of course, they won't relook at those. But there's some other things here. Could you talk about the things that would either delay or reasons they shouldn't do and these re-examinations?
Sure. So, you can see the list here, but being over the age of 55 is a reason. Having the minimum rating, tinnitus only rating is 10%. They're never going to re-examine you for that. Or if you have your back at 10% for painful motion, they shouldn't be re-examining you. I've honestly, over the past years, been seeing, I feel like, a reduction in how often VA does re-examinations. I'm finding that they're just marking disabilities as static much more often instead of scheduling them for future review examinations.
And someone can find out if they're static or not by looking at their code sheet. Now, typically, you have to have your C file to see that. Although I called the VA and asked them to send me my code sheet, and they did that. I have talked to veterans who asked for the code sheet and they said they wouldn't send it, right? So I guess it's the person you get on the phone. But that would be a big help to some of you veterans out there to lower your fear, is to look, because it says right in the code sheet what's static and what's not. So if you see it's static, you just don't have to worry about a re-examination.
If you call VA, 9 times out of 10, they'll send you a code sheet. Just tell them, hey, I want the code sheet from this April 2023 decision. And they can email and fax those now. It used to be they would paper mail it and it would take a month, but they'll send a secure email now if you ask them, so you can get it right away. And I wish they would send that out with the rating decisions, because code sheets contain a lot of important information. It's a nice summary of all your disabilities, their ratings, whether it's static, effective dates. It also contains a list of everything you've been previously denied for.
It also shows the bilateral factor.
Yes. Yep. It'll show your exact bilateral factor percentage. And then there's a block at the end of the code sheet where VA will do note to themselves. The code sheet's considered an internal document, but I've seen things where it identifies a new claim that the veteran should make. And it'll say that, this claim reasonably raised another claim, send out a development letter to the veteran and invite them to apply. And then that development letter never gets sent out. VA forgets to do it. And so the vet doesn't know that there's actually another pending claim here. So there's interesting things in the code sheet.
Yeah. And another thing that on this slide that was important is veterans out there, if you have a disability you want to file for, I hope this reduces your fear that they're going to come after all your ratings. They're not gonna. They need a reason. And as long as you don't ask them to re-examine a static condition, they're not going to do it. Like increased backfires. I see it. I just mentioned it a minute ago. Some veterans that I've, advised, have asked for increases when they're already at the maximum. And it drives me crazy when that happens, because they got reduced simply because they didn't check the schedule, really. So always check the schedule. But at the same time, when you do these increases, you need to fully document your functional impairments and limitations, because that will avoid future reductions. You'll be able to fight them by saying, well, my statement on such and such a date, I noted that I have problems standing for over 10 minutes. I still have problems standing for over 10 minutes. And that fact alone would stop the reduction. So you have anything to say about these increased requests that people do?
Yeah, a lay statement is huge. It's one of the most important things you can do. And if you're going for an increase, I recommend starting off your statement with something like, things have gotten worse. Make it clear that you have not improved, because if VA comes back and proposes, you can point to your lay statement and be like, I made this claim because things have gotten worse. And that will make it difficult for VA to make that finding of actual improvement when the veteran themselves are saying things are not improved at all.
Yeah, exactly. And that makes a big difference at the board, for example. If a veteran has to finally go to the board to fight his reduction, the judge is going to look at that and say, well, the veteran has said he hasn't improved. So, okay, I don't see any evidence saying he has improved functionally. So I'm not going to go with the lowering. So it's really important to get that statement in.
Super important. And then another thing I would note is, VA will often tip you off if they're considering a reduction. So if you make an increased rating claim and VA continues it, you need to go read the narrative portion of the rating decision where they explain why they're continuing it. Oftentimes they'll say, we've noted an improvement in your disability, but sustained improvement hasn't been demonstrated. And that clues you in that VA saw or believes that you might have improved, but at this point, there's not enough evidence to reduce it. So it's just good to know what VA's thinking.
That's true. Definitely, I tell everyone to fully read their decision notification, because you'd be surprised sometimes of what's in it.
Yep.
And here's a couple examples, both from 2023, by the way. So these are recent decisions, and both about hearing loss, which I've seen tons of people get lowered or get proposals to be lowered on hearing test results. The difference in these two particular decisions is where the judge at the board, one of them considered functional improvement and one of them just completely ignored if there was functional improvement. So, I mean, it's really important that you get that in the record about, you need to make it clear that it's gotten worse, right? Certainly that it hasn't gotten better. And here, for instance, in this one where functional improvement was taken into account, the judge specifically points to the veteran has been consistent in his reports that his hearing has not improved. That was the key thing here. The judge said, hey, yeah, sure, the test shows improvement, but the veteran still can't hear under his normal circumstances of life, right? So, and the judge who didn't consider it, I mean, that's a problem. So, I mean, what will a veteran do with the one where the judge didn't consider it?
You need to appeal that to the court, the U.S. Court of Appeals for Veterans Claims.
Because that's like a for sure,
yeah,
I know
I would
the court
take that
doesn't.
Case.
Go ahead.
I was gonna say I would take that case. I would almost certainly be an automatic remand from the court instructing the board to consider the rating reduction under the proper legal standard, which is this actual improvement under the ordinary conditions
right.
of life.
I mean, this is like a no-brainer, right?
Yeah.
And because anytime, and that's what I hope veterans are getting out of this is it's really difficult for the VA to actually succeed in reducing someone because of the two-part consideration. Not only does the schedule have to meet the improvement criteria, but functional improvement has to have taken place. And
right.
that is, for one thing, really difficult to prove, right? And most often it hasn't taken place.
It honestly never takes place. The RO never finds that. You'll see in the second paragraph under the second case, although the exam supports the reduction, the RO did not address whether it was actual improvement. They never address it.
Yep. It says they didn't even consider whether there's, the condition improved under ordinary conditions of life and work. So, I mean, it's, again, veterans out there, these reductions often are, I think a lot of veterans just accept it and move on, or they check the internet a little bit. But the thing is, it's really, really difficult to lower someone if you know how to stop the lowering. And let's talk about that, about people who've got lowered, right? So a clear and unmistakable error, if they lowered you and didn't consider all the facts, you can fight that.
Absolutely. I've won cases from the 70s where VA reduced a rating, and 50 years later, we file a Q claim against that rating reduction from 1970. And it all comes back to this finding that the RO is required to make that finding of actual improvement. They have to make that finding. And when they don't, it's considered to be a rating reduction effectuated without observance of law. And you can win a Q claim when VA fails to follow the law or properly apply it. And so any vet that's ever been reduced for a rating, chances are they have a winnable Q claim. And if you win that Q claim, and you're generally going to have to go to the board to do this. The regional office is not going to grant it. You're going to get denied. You'll have to appeal to the board. You'll have to wait whatever the backlog is, currently 3 to 4 years, which is absurd. But in most cases, the board will grant these Q claims and they'll restore that rating, back to the date it was reduced. And that can be a huge amount of back pay.
Wow. Is there any other facts here about Qs that people should know?
I mean, it really just comes down to that actual improvement. You'll want to look at the rating reduction decision. You need to go to the narrative portion and see what findings the VA made. Almost always, it's going to be a simple thing saying, the most recent exam showed you didn't meet the criteria for your current rating. We're reducing you. They don't make that finding of actual improvement. And if that finding's not in there, you probably have a winnable Q claim.
One thing I found is some veterans are pretty bad about checking their records. They either don't have their C file or, the VA sending these C files on disk, right? Some veterans don't have, they don't even put DVD players in computers anymore. So some people have a problem getting to their records. For example, if someone contacted you, for example, and said, I think I have something, but I don't have my records handy. I was reduced 10 years ago, and I don't really know the facts. I mean, how does that work if someone had contacted you about a situation like this?
There's one of two ways you can do it. I can sign a veteran up and just do a power of attorney and say, hey, we're doing this so I can get access to your claims file. And attorneys and representatives can use a program called eFolder, where it downloads a zip file of every single document in the veteran's file. And then I have a program that renames it. But in most cases, if a vet tells me they had a rating reduction 10 years ago, there's probably a winnable Q claim. And so if the vet wants me to represent them, I'll sign them up just based on, them telling me they had a rating reduction. And, I'll say, I might get into your record and see this is not winnable, and I'll withdraw. But yeah, I get full access to the file. The first thing I do with any case, regardless of what a vet hires me for, is to review every single page of the file, because I'm looking for things like this that, maybe the vet even forgot about. They didn't remember they got reduced 40 years ago. And,
Yeah,
they're
and
coming to me.
that's one of the things. If someone's been reduced and they're not sure what, if they were reduced properly, to me, the best thing to do is to contact a lawyer, right? And because a lot of lawyers, as for instance, you, for example, and other lawyers, will go ahead and look at your file to see if there's a case there, right? So that's what you do out there, veterans. If you're not sure what to do, go ahead and seek legal assistance. There's lots of firms out there that represent veterans. Some of them may not say they want to review your files, or some of them will. Right. So you just contact lawyers who will do it. And hopefully you can get an answer whether you have a case. I've never been reduced myself, but I talk to veterans at least a couple of times weekly who have reductions letters. So those people who have them in the past, you really need to check out to see if the VA properly did it. So you may have a lot of money on the table. So is there anything else you got to say about reductions?
No, the bottom line is fight them. Do not accept them. Don't ignore the letter. You only have 30 days from the letter. And by the time it reaches you, it's probably already been a week or two before you actually open up the envelope.
Actually, I've had veterans who the letter was already 45 days old when they got it.
Yeah.
So they have 15 days left, right?
Yes.
So yes, that's 60 days from the date on your notification, which isn't necessarily the date they sent it to you.
Right. And you know what, even if you're past the deadline, you get 30 days for a hearing, 60 days to submit evidence. If you're past the deadline, still make the request. I had a case at the board where a vet didn't make his request for a hearing until 90 days, and the RO refused to hold the hearing, reduced them, and the board overturned it based on the fact that the RO wouldn't give the hearing. The deadline is actually, it just says that if you don't meet the deadline, VA may still reduce it, but doesn't say if you file the request for a hearing after the deadline that VA won't give you a hearing. They still have to give you that hearing.
Okay. So there's another element that veterans, but veterans don't go past that damn 60 days.
Yeah.
Right? Don't mess with it, right? Because
right.
If the ROs, definitely, if you go past that time limit, they're reducing you, and you don't want to go and wait 4 years at the board or more for them to say, okay, they shouldn't have did that. Anyway, so I don't think we have anything else to say here.
Thanks for having me again, Eugene. I enjoyed it. And again, vets, if you've been hit with a proposed rating reduction, please fight it. You can win it.
Exactly. Great having you on again. And if you haven't bought the book yet, go buy it now. It's called The Irate Veteran, available at Amazon. What else would it be called, right? And it tells my story, and it also tells the problems at the Veterans Administration. It also has my recommendations for how to fix those problems. So every veteran needs to read it. Matter of fact, every American needs to read it. And that's all I got to say. Irate Veteran, out!